We are proceeding with our next speaker, and a few topics have generated more discussion in football over the past years than the Diarra judgment. Many believe its long-term impact could be compared to the Bosman ruling, potentially reshaping the relationship between players, clubs, and the transfer system itself. Our next speaker is one of the leading specialists in international sports law, advising football stakeholders on regulatory, contractual, and transfer-related matters at the highest level. Please welcome to the stage Roy Vermeer, founder of Vermeer Sports Law. Give one round of applause for him.
Thank you. Thank you very much for the kind introduction, and happy to be back in Belgrade again. So what I will do today what my intention was today, was to speak about the Diarra judgment and the consequences for the transfer market. However, yesterday reality got caught up with me because FIFA introduced new transfer rules. Yesterday evening, 10:30. I was in bed at 10, so I only saw this morning. So I basically had to cut my presentation short, change it a bit, so it will be a little bit shorter than initially intended. But I will also go through those new rules, which I think is good news for agents and clubs, because the transfer market is saved, so to say. And there are some interesting new rules, for example, as well, that players under the age of 18 can now sign contracts for more than 3 years, so for 5 years even, which is quite a mind-blowing new rule in the FIFA regulations. So again, I know that not everyone here is a lawyer, so I will keep it pretty to the point in terms of what this ruling actually entailed. I will go over some of the amendments which happened in the meantime, but also on those that were published yesterday. These were some other items I wanted to do, but that is old news after yesterday's announcement. So, for those of you who may be aware of the FIFA RSTP, there is a certain provision in their article, the famous Article 17, which provides guidance on what needs to be taken into account whenever a player terminates his or her contract before the expiry of the end date of the contract. We know that this is different from most of your national laws. I'm from the Netherlands. If I would have a 5-year contract and I wanted to terminate after 3 years, I would have to pay the remaining 2 years of the contract, and I'm gone. I'm going to a new employer, and everything is fine. This does not work like that in football, at least it was not supposed to work like that. So FIFA made rules which kind of made it harder for players to do that. Why? Because otherwise you don't have a transfer market, right? Because if a player can in advance calculate and know exactly what he has to pay, and it's a reasonable amount, obviously there's no point in Manchester United paying 40 million for him to his former club. He just pays the remaining 2 years by himself, and the 40 million that Manchester United pays as a transfer fee can go to him. So this is something that FIFA obviously wanted to avoid, and there's Article 17, which says that for the calculation of compensation for breach of contract, you need to take into account the law of the country concerned. Forget about that, because that never happened. The specificity of sport, whatever that may mean, nobody until today still knows what that actually precisely means. And then other objective criteria, such as the player's contract that was terminated, the value of the player's contract, where the player went to, so his new contract, non-amortized expenses incurred by the club. So for example, your club has paid a transfer fee, the player leaves after 3 of the 5 years, then the non-amortized part needs to be taken into account for the calculation. So you, as an employee, as a player, are being held responsible for a fee that has been negotiated between 2 employers, which you won't find normally in normal employment law, and whether the breach falls within the protected period or not, which is depending on the player's age, the first 2 or 3 years of the contract. Then there's also the rule that if a player had to pay compensation, the first club that the player joins would be jointly liable for that compensation. And also sporting sanctions, of course, are considered if you terminate within the protected period without a valid reason, you could be banned as a player for 4 months from playing football. And then there was the ITC procedure. If you're an agent, then you know how annoying that ITC procedure could be in the past, because clubs would just object to the ITC, and then the new club would be annoyed. You had to go through FIFA. Some clubs didn't understand the rules, so didn't know that FIFA could intervene. Ultimately, you could get the ITC, but it was a kind of blackmailing tool for clubs. So just as an example how the calculation would look like back in the days, at least at FIFA proceedings, if a player would be sold for, or would be bought by a club for 10 million, and there would be a contract for 5 years in which the player makes a yearly salary of 1 million, and this player then terminates the contract and says, I go to another club because I can make 2 million a year. This would be the calculation at FIFA level. So they would take the rest value of the terminated contract, which is 2 times $1 million. They would take the value at the new club for the corresponding period of time, which is 2 times 2 million, and they would then take the average of that. So you have 6 million in total, divided by 2 is 3 million. And then they also take the non-amortized transfer fee, which in this case, if there's the transfer fee is 10 million for a contract of 5 years, if you terminate after 3 years, the non-amortized transfer fee is 4 million, and you end up that you as a player have to pay $7 million US, the new club being jointly liable. At CAS level, which is the appeals body for the FIFA DRC, there would be a little bit different. There, the calculation would be based on Swiss principle of positive interest, which basically says that you have to put the party back in the situation that it was in before the breach of contract. In practice, that then basically means that you can bring up any kind of damage that you would like transfer values, transfer offers that were not being taken into, transfer offers that were being made to you, replacement costs, etc. In that sense, at some point in time, you, as a lawyer or an agent, could not really inform a player anymore what more or less could be the compensation that he had to pay if he would terminate the contract unilaterally, because it would be dependent on so many factors which the player had no influence on. For example, if the player would terminate and the club would come up with an offer of a week earlier of 50 million from another club, then in principle the Court of Arbitration for Sport could take that into account. And you then also sometimes saw in procedures that clubs would fabricate these kind of offers, or had a club so they were a friend with come up with an offer to kind of increase the compensation to be paid. Now, obviously that leads to a situation in which there's no clarity, there's no legal certainty for players to terminate the contract. They cannot make an informed decision, and therefore they rarely ever terminate contracts, which equals the transfer market. Because now, instead of player doing themselves, it's going to be a negotiation between teams. If you look at the other side of the medal, which is the clubs terminating a contract with a player because, for example, they don't want him anymore, he's injured, that compensation was quantifiable exactly, because it would be in the rules saying, okay, at maximum you have to pay the residual value of the contract. If the player finds a new club where he earns new salaries, there's a mitigation, and therefore clubs would know what their maximum damage is, players would not. That brings Diarra into play. What happened to him? He was employed by Lokomotiv Moscow. He then leaves Moscow and does not return. He, in the beginning of his case, alleges that there were some incidents about racism. He then doesn't bring that back in the appeal procedure, but anyway, he does not return to Moscow, even though Lokomotiv Moscow asked him several times to come back. And then Lokomotiv Moscow terminates, because if a player is gone for a certain period of time, and despite default notices does not come back, then you can terminate the contract with a valid reason. At that point in time, Diarra wants to sign with a new club in Belgium, and they write to FIFA and says, "Well, I want to have your green light that I can that I can go to Charleroi. I want confirmation that this Charleroi is not deemed jointly liable. I want the ITC to be sent, a guarantee, and I will not be, and the club should not get a transfer ban." FIFA does not confirm, and the deal falls through and the player remains unemployed. And that was actually the basis of his claim in front of the European Court of Justice. Ultimately, FIFA and CAS ordered both the player to pay 10.5 million euros to Lokomotiv Moscow, which is a big amount, but not so odd actually, because his contract was also big in itself, so it was not even more than the residual value of the contract. So Diarra is someone who likes litigation, it appears, because after CAS he goes to the Belgian court and then to the European Court of Justice. There the European Court of Justice gives a very clear ruling saying that the FIFA RSTP, especially Article 17 and also the rules around ITCs, infringe freedom of movement rights and violate competition law. And they're very specific on the points that FIFA has written in Article 17 to be relevant for the calculation of compensation. So they say for the law of the country concerned, it's all nice and well that you've put that in your regulations, FIFA, but if you never apply it, it's useless. So they're very critical on that part. Then the specificity of sport, as I told you, nobody really knows what that means, and some CAS decisions would say, okay, an extra 6 months of compensation here, an extra 9 there. The European Court of Justice says, well, this is far too vague and discretionary. We cannot take that into account either because nobody really knows what this entails and how it is to be applied. The terms of the player's new contract. So player terminates and he goes to the new club. As I said to you, the FIFA DRC would always take that into account to calculate the value of the player. They say this is irrelevant because it has in essence nothing to do with the contract that is being terminated, and therefore with the contract from which the damages exist. And then finally, and that's a very important one, is the non-amortized transfer expenses. The Court of Justice says this is excessive. You cannot take into account a component to calculate compensation for an employee towards an employer for fees that are being negotiated by two employers. Why do you do that? That is something between clubs, and that's only to ensure the proper, that's only there to kind of protect the financial interests of clubs. So from that moment on, transfer fees should not be held accountable to the players. Now we will see in the new rules to which I come that's back in the equation, but that is what the European Court of Justice said. If you do this, have those fees between clubs, then you're infringing the freedom of movement rights and competition law. On the joint new liability, the automatic one of the new club, and also on the sporting sanctions, in the FIFA regulations they said these are automatic. It doesn't matter if you had any role as a new club in inducing the player to terminate the contract. It doesn't matter when you sign it, if it's the day after or 2 years after the contract was breached. You are automatically jointly liable as a new club, and therefore you can also be hit with a transfer ban if you are in that position. Also from that they said this is completely disproportionate. We don't think, the European Court of Justice said, we don't think it's necessarily illegal, but the automatic part of it is definitely illegal because there always needs to be a case-by-case basis of whether the club actually had a certain role in the premature termination of the contract. And on the ITC, also this rule that you can prevent the player from registering with a new club automatically, or at least for every case, is not reasonable. So that, in conclusion, is that if the player terminates his or her contract without a valid reason, the manner in which the compensation has been calculated for more than 2 decades has been declared illegal. You may have seen the complaint, the collective complaint that was filed in the Netherlands by Justice for Players, They've started proceedings against FIFA and various sports of national associations, claiming damages from them for these for the last 20 years. I think it's around 7% of salaries, saying that because of the transfer system, players have missed out on that. I think something similar is being considered by the agents, because also the agents could argue the same, that because of the transfer market, they have also endured losses. The automatic joint liability in the sporting cases is incompatible, so that also needs to be removed, and FIFA, in short, needs to change its rules. They first then do that by putting something rather vague in their regulations. Why? Because I don't think that they really had the answer by that time, and they also wanted to protect the transfer market, so they went with the implementation of the positive interest principle, which is odd in a way, because that was exactly the kind of calculations in which everything is possible, because on the basis of the positive interest principle, you can argue all kinds of damages, including, again, transfer fees. So this was quite an odd solution for FIFA to put in the regulations, but it did the trick, at least for the last year, because where some thought, and including myself, that we would see more player terminations because the European Court of Justice had been so clear, and so blatantly clear in what they thought of the system, that it would be perhaps more appealing or attractive for players to terminate the contract, and instead of waiting for someone to offer a transfer fee, just to go to that new club. However, because they put this in there, what happens is quite obvious. When a player comes to me and say, hey, can I now, after Diarra, terminate my contract without having to pay whatever amount? I say, well, yes, but there is now a new rule in the FIFA RCP, and I cannot guarantee you. And players, if they want to take a certain decision, they want to have guarantees that they don't have to end up paying 20 million when their contract is for 10,000 euros. And I cannot give that guarantee, obviously, because of the vague wording that was included. At the same time, the joint liability rules were changed. It was now then on the former club to prove that the new club had a role in the premature termination of the contract. So that was better, I think, for the players in terms of movement, because if a player would terminate, the new club could just sign him and register him and not worry about any claim for compensation afterwards. Sporting sanctions the same. Those were also only have to be applied when there is an actual inducement. Now, previously I would have then this conclusions, or at least talking points about what the consequences were of the Diarra judgment. It's definitely that it's more difficult for clubs to calculate and prove damages, because there is not a presumption anymore, and also not in Article 17, certain components which have been included to always are to be a damage are now removed. It should, in that sense, as I said, should be easier for a player to terminate or at least calculate the compensation, yet the uncertainty remains. Now, there is leverage in that, because, for example, in the last transfer period, I do know that players who were being held, not hostage, but who clubs said, no, we're not going to have a transfer this transfer period because the transfer offer that is being made is too low. They would say, oh, then I'm going to do a Diarra. And then clubs all of a sudden became maybe a little bit more willing to negotiate. And that's definitely with, for example, we had a player in the Netherlands who was maybe on 2,000 euros a month, and a big club from Belgium came, and the Dutch club says, no, we're not going to do that because it's not enough, and it's a multi-million-dollar offer. if he would have terminated the contract, then I think on the Diarra rules, he would have had to pay maybe 24,000 euros at max. If you say that in those negotiations and the difference between a missed transfer offer of 3-4 million and 24,000 euros, that will definitely get the club going. So that happened, and I think that will still be able to happen in the upcoming transfer windows. What you previously had at FIFA and also at COS was, and it costs a little bit less, but at least a bit of a coherent kind of decision making. You would know more or less how the compensation would be calculated. That is after the era a little bit more in the air. So there's less coherence, less consistency. And I think also more clubs started to use compensation clauses in the employment contracts. Very high, obviously, so that the player could never trigger it. That raises, I think, freedom of movement questions in itself, because from my point of view, if you put in a player's contract a liquidated damages clause or a release fee of an amount that he can never trigger himself, are you not also violating the freedom of movement rules? And then, of course, I said, okay, there might be less transfers, but then there were record transfers in 2025 and 2026. So the market just continued whatever. Now, as I said yesterday, then FIFA announced the new regulations. And they call it, or at least in their press release, the 11 key points of the 2027 transfer system. And it's quite remarkable what they have done, and also, well, remarkable, impressive, but they have, as they said, saved the transfer market. So again, this is, I guess, good news for the clubs and for the agents and also for youth academies and the academies. And I will very briefly just go over them. First one is, and this is really, really new, it's the global social dialogue, which basically means from now on, these regulations will not be changed without the consent of all stakeholders. So these are the stakeholders in that context are the clubs and the leagues on the one side and the players, player unions on the other side. So now, all three of them will have to agree to changes to the RCP, and FIFA cannot do it unilaterally anymore. So you could say it's a CBA-like agreement, which has advantages for FIFA because in Diarra they were being held accountable or liable for violating competition law. There is a rule in competition law that says if certain rules are being made in the context of collective bargaining, then you are exempt from competition law. So they can use that to go to the court and say, hey, FIFA, but these rules are actually agreed by all stakeholders, everybody agrees. So yes, we restrict the movement maybe of one or two of players, but the players' unions have agreed to it. Secondly is the consequences of a breach of contract. There's a new structure for liability, compensation, sanctions. So for example, for the sanctions, it is more higher. It used to be, okay, if a club terminates the contract without just cause, you get 2 seasons registration periods ban. That was never really enforced, but now it is being put in a more of a schedule. So in a table, the first one is a fine. If you do it for the second time, there will be a transfer ban for only 1 season. If you do it for the third time, it's for 2 seasons, etc. Liquidated damages clauses. These are the clauses, of course, there in which in an employment contract you agree upon what the consequence be, what the compensation for a player or a club is, and what needs to be paid if he or she terminates the contract without just cause. At FIFA DRC level, there was a very consistent jurisprudence saying, hey, if you agree upon those clauses, it needs to be exactly the same for both parties. So if the club terminates without just cause and he has to pay 3 months, then it should also be the other way around, that if the player terminates, he has to pay 3 months to the club. Otherwise, it would be disregarded. Now, FIFA has now explicitly said that is no longer the case. It doesn't need to be reciprocal. You can agree upon whatever you want, and there we will show restraint we will show restraint in reducing those clauses, which is, I think, quite significant for the clubs, because if you now put a really high compensation clause in your contract, and the player wants to challenge that, then there's very little room, I think, still for him to challenge. Whereas at FIFA DRC level, at least before this, there was a lot of room to challenge that. There's also a certain threshold now in the regulations that says that kind of protects players who earn less than others, or at least who are maybe considered less fortunate. That threshold is put on $150,000, which is quite a high threshold still, if you ask me. But those players should always receive the rest value of their contract. So if you have a player who makes 80,000 euros and you put in the contract that there is a compensation clause for 3 months and there is still 3 years to go when they terminate, that will not be accepted. That will be the rest value of the contract and the clause will be disregarded. The calculation of compensation, FIFA says that they've put in their objective and transparent criteria. One of the things which is, I think, remarkable in light of the Diarra case, but good for the clubs, and it is now also then accepted by the player unions, is that it brings back lost transfer fees and transfer value. So clubs can argue that if they have received a contract offer for 50 million just 1 day before the player terminated, that is a compensation that the player will have to pay to the club. So you see that Diarra, they said, okay, well, these fees negotiated between clubs, we don't understand at all why they should be put on the player. FIFA now brings them back with the consent of the stakeholders. The minimum compensation. I said in the beginning, normally if a player terminates with just cause, or a club without just cause, the remaining value of the contract needs to be paid by the club, and it can be mitigated by whatever the player earns afterwards. That is also out, or at least in principle out, because seemingly there is no mitigation anymore, except for coaches still. They were not part of the discussion. So, but as a minimum, the rest value needs to be paid whenever there is a termination where the club is at fault. Also a specific rule on abusive conduct that used to be kind of taken into account only for sporting sanctions, but now there is an explicit rule that there is a 6 months extra penalty for a player or a club which acts abusive. From the club side, you will often see that the player is being ordered to train alone, or as we had the case Salvatore with the player being beaten up in the training ground, etc. So you can see that there is, in the most egregious cases, where there is abusive conduct, 6 months can be added. The joint liability of the new club, I find this a monster. I don't like this provision at all, because what will happen now is basically, instead of the automatic joint liability, what will happen is that the rules say that if a player terminates a contract, if he signs with a new club within the first 45 days after the termination, then that new club will be held to have induced the player unless it can rebut that. And I think what you will see in practice is basically clubs just waiting for 45 days. That is how it's going to work. And I think that is not good for anyone. I also don't understand the ratio for the rule. But yeah, I think that will have a very detrimental effect for something that is not that necessary. One of the most remarkable rules, I think, is 8. Under the old FIFA RSDP, players under the age of 18 could not sign contracts for longer than 3 years. Now they can sign under certain conditions. If you've been in the club for longer than 20 months or 2 seasons, whatever it's shorter, you can sign a contract for 5 years. I don't think this is particularly good for players, because if you're 16, you're kind of happy to sign whatever, and then until the age of 21 you'll be held to a contract at such a young age. I would say, well, how does that interlink with the prohibition on the exploitation of young adults or minors? But okay, this is what FIFA went for, together again with the stakeholders. This is only limited to 5 new contracts per club per year. And there needs to be there's rules around salary increases in the fourth and fifth year, but well, you know, if you're making 1,000 euros, then in the fourth year it's 1,200 because there's a 20% increase. That's not that great. And then the last one, and then I will give the floor back to you, is the players' participation in transfer fee. There is now a rule saying that if you earn less than 150,000 euros, I don't know why there's a difference between euros and US dollars, because in this one it's euros and the other one was US dollars, but maybe it's a mistake. And you're transferred against the fee, you get 5% of the transfer fee from your releasing club. The player can then waive half of that, but not more. And that's a very, I think, a very new rule as well to kind of, you know, put the player. I guess it's done to get the players to and the player unions to subscribe to the transfer system on a longer period of time. So that's it from my side. If there's any questions, happy to answer. Otherwise,
thank you, Roy. No, keep the microphone.
Yeah, I keep them. I'll take it home.
Keep the microphone because I'm sure we do have questions for you. I can see in the first and the second row very distinguished gentlemen and one wonderful lady. I assume they are from law, you know? I assume they are from sports law, so I'm sure they do have a question for you. Yeah. Do you have any question for our speaker row? They do. So can we pass the microphone? No, I'm fine. Keep yours. Thank you.
Thank you, Roy, for speaking on this very important topic. It was truly a pleasure to hear from you. Now, I know that new RSTP was made public yesterday at 11 p.m., so it's very early to speak upon it, to give an honest opinion and thorough opinion on it. But in your overall opinion, is this a step in the right direction? And that given that the new RSTP will enter into force in January 1st of 2027, do you think that maybe we still have time to correct some of the mistakes, especially the 45 days that you mentioned, before they enter into force in January 2027? Thank you.
To start with the last one, I don't think so, because it's already been published in the RSTP as a set regulations, right? It's not like high-level lines and this is going to happen. It's in the RSTP. It's published on the website, and it's going to be implemented as of 1 January. As to the first question, it's a hard question. It depends also who you represent, I guess. I'm luckily I'm no longer in the player movement, but of course I'm very much influenced by that, by the movement still. Look, I think that the underprivileged players, if I can tell them that, they will have better protection. So I think for them it's good. I think for clubs this is very good, very, very good. To be welcomed, and for the transfer market in itself. I've always had some reluctance to the transfer market, although I also understand that it's good for redistribution of money. And with this green light, it's great for them, I think. I think the players that will suffer from it, and we don't have to feel sorry for the guys who, of course, who are very fortunate already. But yeah, I think the movement rights that had won in Diarra, they are now basically gone. Which is also okay if you get stuff back. I think they got good stuff back, and this is it's not only RST, by the way, because there will also be the player protection fund will be back, which is great. There will also be some new rules around the match calendar, the health of players, etc. So I think both parties probably won something and lost something, and that's in the end of the day that's the good result of the CBA as well. If everybody is unhappy, FIFA did a good job.
Oh, that's nice to hear. They didn't make it any more complicated, or it's even more complicated with this kind of laws, or it's more simple? How they made it?
Say again, sorry?
Is it more complicated, or is it more simple, or is it more complex? What is your opinion, maybe?
I think it's probably getting a little bit more complex now, but that's not necessarily a bad thing, definitely not for sports lawyers. Yeah, no, it's getting a little bit more complex, but not that much.
Right.
And there are some really good rules in there also for both sides. So I think everybody can. As I said, everybody. It was very negative. Everybody is a little bit unhappy. Everybody is also a little bit happy, I guess.
Thank you. Do we have more questions? We do have more questions from Ksenia. No, go for a microphone. Just a second.
So this is a hypothetical question. So if you're having a contracted competent law like FIFA regulations and Swiss law, and we have the agreed compensation, but when we have a dispute and we go to the dispute resolution, can we challenge the agreed compensation from the aspect of Article 337, lit C of Swiss Code of Obligations, which is a mandatory principle which prescribes that in case there is a termination without just cause, the residual value of the contract is...
I think you will struggle more because normally at CAS, at least the Swiss law would only come into play if the FIFA regulations would be silent on elements. Now it's the FIFA regulations are not really silent on it anymore, what you can and cannot do.
But you can challenge CAS award before the ordinary court. And
Yeah.
that is a public policy, Swiss Code of Obligation. Hypothetically, but in the long run,
Yeah.
how do you pursue?
So you're saying, okay, there's a compensation clause, we first go to FIFA, and there we argue that the compensation clause is not complying with Swiss law, and then we go with CAS, and then we go to the Court of Arbitration, to the Swiss Federal Tribunal to say it's a public
if
policy.
you want to take more than it was agreed, in respect of the mandatory law.
Yeah, no, that's an interesting one. I couldn't answer that one, but it's
Try. In Switzerland, for example, you can go before Swiss Federal.
They would check the public policy before the SFT, so you wouldn't have to go to the National Court, I guess, of Switzerland, right?
Because there is a conflict with the
Look,
Swiss law.
Yeah, but do you think this would be 100% considered a violation of public policy? Yes, you think so? Okay, well then it should be. But look, there are certain rules indeed of Swiss law which you cannot amend, right? Because they're mandatory and therefore you cannot
Like
change
that provision.
Yeah. Well, I think you have a good shot, yeah.
Okay, thank you.
Thank you. Thank you very much. Thank you, Roy. Roy Vermeer was on the stage. Please give one more round of applause for him.